Uh, Welcome to a very confused Uncivil Law, where we learn through the misfortunes of others. So, yeah, here's the problem, guys. I was thinking about covering the new Without a Crystal Ball lawsuit, because Todd Chrisley, I think, is suing Without a Crystal Ball, and I don't know if it's in federal court. If it's in federal court in Minnesota, that would be great, and we can ignore this entire discussion. But there was a suggestion that this is being filed in state court, which you can do. Okay. Well, I say that. I'm sorry. I've already misspoke. I said filed in state court. Wow, that's how broken this is, guys. Yeah, I said it could be filed in federal court or it could be filed in state court, and I misspoke. That's the problem. It doesn't have to be filed. I'm not sure if we have the ability to cover it, because we literally have no ability to get it, because we can't get it from the court because the court doesn't have it. Do you get this? So apparently in Minnesota and North Dakota and South Dakota, you can have a lawsuit and exchanges of papers and stuff, and the entire lawsuit exists outside the court system, but it's a real lawsuit. What? So, okay. All right. So this, I think I understand this article, but we're going to work through it together. So this is called pocket service or pocket filing, hip pocket service or hip pocket filing. Seems to be the terms that are used for this. So here's what's happening, okay? In Minnesota state court, unlike most states, a civil action is commenced upon service of the summons and the complaint, not the filing. You get that? The action, the civil action, which is otherwise known as a lawsuit, the lawsuit is commenced like a real bona fide actual lawsuit. It commences not with filing, which is how you would bring it to a court's attention, but by summons and complaint. So let's just break down what that means. If you're in Minnesota, and I'm understanding this right, and it's breaking my brain. So what that means is a lawyer can just send off documents in the mail to someone else with the whole, like, you are being sued, right? And they will look like court documents, hopefully, but there's no file number. There might not even be a court listed. And so you might be thinking to yourself that this is just a threat, or you might be thinking to yourself, this is a scam. But no, it's an actual lawsuit. It's not filed in court. But it's a lawsuit. So if you get something in mail that looks like legal documents in Minnesota, I suppose you have to respond to them, because you can't know if it's a scam or know if it's real, and if you don't respond within 21 days to this non-filing, you lose. Now, that's pretty typical for filing, right? A 21-day period to respond is pretty typical. Sometimes it's a little longer, 28 days, but 21 days is pretty normal. So in normal land, you have 21 days from filing to respond. But in this case, you have 21 days from random receipt of random documents. And if you don't respond, you lose the lawsuit. because it's you're defaulting because you didn't respond to the lawsuit for want of prosecution. So you lose. So that means the person can go into court and get a default judgment against you for the lawsuit that you didn't respond to, even though the lawsuit was never filed in court. I'm trying to understand it as we talk as well. This is fun. Okay. If you or your client is served with a summons and a complaint with a Minnesota court caption, which I'm not even sure it necessarily needs the caption, to be quite honest, but no court file number, do you have to respond? The answer is yes. You must answer or otherwise respond with a motion to dismiss, which I don't even know who that motion is being filed with necessarily, because the defendant can file with the court, but they don't have to. See, they have to respond, but they don't have to file in court. So if you're the defendant and you wanted to, you could respond with a motion to dismiss that's not going to be decided by a judge because a judge doesn't know it exists. And if you don't raise defenses, you lose them, because remember, it's a real lawsuit. So you can't not file a motion to dismiss if you have grounds to dismiss. You can't not file the motion to dismiss, because if you have grounds to dismiss and you don't file the motion to dismiss, you lose them. You use them or you lose them. So you can't not file the motion to dismiss. So you're filing a motion to dismiss, which is a motion presumably to a court, but there is no court because there's no judge. So you're asking, you'll often see in lawsuits, it's a little bit old school these days, but you'll often see at the end, they'll literally call it a prayer for relief. I guess this would be the most literal version of that prayer for relief, because in this case, your prayer is going to be answered not by a court, but by the ether or a higher power, I guess. So you're literally making prayers for relief or something. I don't understand. Default judgment is not automatic, that's true, and can be vacated. Yeah, but there are rules, and yeah. But you should not ignore a Minnesota... Say it can be vacated isn't to say it's easy or automatic, by the way. But you should not ignore the complaint just because it is served and not filed. Now, if it's filed in federal court, then none of this bullshit applies, because federal court. And Minnesota state law can't dictate what happens in at least procedurally, in a federal court. So if this is federal court, you can ignore all this bullshit. But if it's state court, no. Because a case is commenced upon service in Minnesota, where you literally hand it to the other guy, any applicable statute of limitations is told on the date of service. So statute of limitations require you to, well, they would normally say they require you to file within a certain period. But in this case, it requires you to, I guess, commence the action would be the more technical, correct aspect here. So normally, every lawyer would just say you have to file. Every lawyer I've ever met would say you have to file within the statute of limitations. But apparently in Minnesota, North Dakota, and South Dakota, that isn't true. Because you don't have to file, you just have to commence the action, and you can commence the action without filing. I don't know. The plaintiff may choose to file immediately after obtaining an affidavit of service, or the defendant may file with the applicable court. The keywords in this being may. But often neither party has strong incentive to file right away. Surprisingly, at least to some, the parties may even serve written discovery and take depositions in a non-filed case. So this means this, okay, just to keep up with this, okay, so now not only are you having the complaint sent not in court, not only are you doing the motion to dismiss not in court, and they replied in the motion to dismiss not in court, and all that stuff. Can you imagine if all that stuff without a crystal ball toddy was just being handled by documents going around privately? That's basically all these documents being exchanged, but they're all being exchanged in back channels. I'm honestly trying to understand this as we go along. By the way, this is absolutely breaking my brain. I was when this was brought to my attention by our mod Stephanie today. I had no mental conception of how this made any sense, and I had to read it several times, and it still breaks my brain. This is weird. Why would party not want to file? The primary reason that is until it's filed, it remains out of the public eye, because it's not a court record or a public record, because and it's confidential. I mean, except as the parties might share it, but sure. When and if the case is filed, it becomes a matter of public record. And as of 2021, Minnesota civil cases can be accessed by anyone on the internet. So here's a question I don't know the answer to, and Nick will have to clarify, I suppose. So if you do wind up eventually filing in court, because we're going to get to that, there's a time limit, thank God. There didn't used to be, by the way. But if you do eventually file, what do you file? Do you file just the complaint? Or do you file like all the exchanges of documents that have happened in the case? How would you even do that? I mean, how would you even do that? Because normally, like in a normal case, right, the parties are filing at different times and they get stamped at different times and they get sectioned off at different times. But what are you supposed to do here? File a complaint with exhibits, which will be the longest list of exhibits ever, as you basically attach all this stuff that's happened off the record now on the record. Do the parties have to cooperate? Does just the plaintiff do it? Do they have to simulate? Do they have to simulate what happened by exchanging the documents in turn? The documents that already occurred? So, yeah, I mean, yeah. How do you actually do this as a technical matter? I don't know. According to a law review article, Minnesota is only one of 3 states in the Union, along with South Dakota and North Dakota, in which it's possible to commence an action, engage in discovery, and reach a settlement without ever filing. Wow. So yeah, like every other state, and federally, you can send a demand letter, right? We will sue you unless, and then you could have a whole bunch of private discussions about that. But you wouldn't file motions. It wouldn't even make sense. So if you sent me a demand letter, whatever my response would look like, it would not be like a motion to dismiss, because dismiss what? But now you're sending me, basically, you're effectively sending me a demand letter that is actually in and of itself the lawsuit. I'm amazed. I'm truly amazed that people in Minnesota are not in default all the time. I mean, people ignore stuff coming from courts as it is. But now you have stuff coming from rando attorney. And I'm surprised that people in Minnesota are not in default just constantly. How is that? How's that working? No. Minnesota's rule apparently dates back to 1851 and is currently found at Rule 3.01a of the Minnesota Rules of Civil Procedure, which states a civil action is commenced against each defendant in which the summons is served upon, when the summons is served upon the defendant. Service can also be effectuated by sending a summons by mail and receiving back a signed acknowledgement, which presumably that means literally, wow, that's the most bizarre thing I mean. So if you read that literally, which I have no reason not to, service can be effectuated by sending the summons by mail and receiving back a signed acknowledgement of delivery. So normally, not only do you have to not get a process server to deliver it, that literally means you could literally deliver the summons by certified mail. Signature required. And you could dress up the envelope, your prize inside, or make it sufficiently clickbaity, as it were. And when they sign the card, right, and put that back and give it back to the postal guy, and you get it, you have proof of delivery. So you don't even need a process server. You just need this postcard from the postal office for the delivery. You need it signed, so you actually need a signature. So a tracking number won't do, but certified mail. Signature required. Wow. Or delivering the summons to the sheriff where the defendant resides, so long as the sheriff actually serves the defendant within 60 days. Why would you even bother with the sheriff? Because you can just send it in the mail. So you can serve them in person, so you can get a process server, or certified mail. Okay. And I have to ask the question. What was Minnesota thinking in 1851? Was Minnesota a state? When was Minnesota a state? Hold on. Hold on. Oh, they weren't even a state till 1858. Okay. So apparently the territory of Minnesota in 1851 apparently wrote this, I guess through a legislature or court or something. And what I really want to know, and I don't know if there's any record of this, was this a mistake? Did this person who did this write this with a mistake and somehow it's just remained in place all these years? Or did they actually mean to create this result? And also, apparently, this is also the rule in North Dakota and South Dakota. So what happened there? Did Minnesota somehow pass the virus to North and South Dakota? Did Minnesota, South Dakota, and North Dakota have a road trip in a car, maybe through Louisiana and something, and had some drive-through cocktails, which is a thing that exists in Louisiana? I'm not making that up. You can buy drive-through margaritas in New Orleans. I'd like to say that again. You can buy drive-through margaritas in New Orleans. Anyways, getting back to my earlier point, did Minnesota, North Dakota, South Dakota get in a road trip and have one too many drinks at a drive-through daiquiri bar and somehow decided that this would be their way of showing their best friend forever pack? Okay, and then finally we have some sanity that finally comes to conclusion. And I use the term sanity very, very loosely here. Okay, so even though this has been true for over a century, in 2013, they finally decided they might need some reforms. So in 2013, the Minnesota Supreme Court, so this was created by a court as a court rule. So this wasn't done by a legislature. This was just done by a court. So, fun. In 2013, the Minnesota Supreme Court put a constraint on it. And then they changed Rule 5.04 of the Minnesota Rules of Civil Procedure. Okay. Why did you put it there? Why didn't you just put it in 3.01a where the thing is mentioned? But okay, in 5.04, they put this deadline for filing action. Any actions not filed within the court with one year of commencement against any party is deemed dismissed with prejudice against all parties, unless the parties within that year sign a stipulation to extend. So yeah, the year isn't even a thing, because this doesn't even make sense. I mean, not really, because before and now, either party could file at any time. So the defendant could always file if they wanted to. So either side always had the option of making this a court thing. But now they have to agree to continue making it not a court thing, which is basically the same thing. It's basically opt-in versus opt-out. But if you were inclined to handle it in private, then why wouldn't you just agree to extend it forever? So not even the 1 year thing is a real thing. You could have a lawsuit going on for years, for decades, I suppose, and never find court. This is wow. And this paragraph does not extend to family cases, which are governed by some other different rule. This means the action must be filed within 1 year of service or it must be dismissed. That's not what it says. Incidentally, it's not what it says. It's okay if you both agree on it. This is a harsh consequence, so plaintiff attorneys availing themselves of this process must be very careful to keep the deadline in mind. Or, I don't know, ask the other side if they want to extend. Because the one would presume the defendant would always agree. Why wouldn't they? Because the whole reason the defendant isn't filing this from day one, presumably, what would be the reason? The reason would be it would be embarrassing, right? Because once it's on the public record, it's on the public record. So presumably the reason the defendant doesn't immediately just go into court, I mean, technically there's also saving the filing fee. So there's the money, I guess. But other than the filing fee, the only other reason to keep this out is because of it's embarrassing. But if it was embarrassing a year ago, it's probably still embarrassing. So why wouldn't the defendant agree? So the whole thing sucks. It's stupid. So I don't know how we're going to cover this lawsuit. I don't know how we're going to cover this lawsuit, because if this is what's happening, and this seems to be what's happening, if this is what is happening, then there's no way for me to get a copy of the court documents, because there are no court documents. So I don't know that we can cover the case, because there's no public record for me to pull. And the only thing else I could do is ask to be added to the CC list for the attorneys. But what's the point there? I don't know. So this thing is this yeah. Yes, Incredible Hulk. I do have an email. It should be in the description. Yeah, Stephanie did get to have dinner with me, and she's going to have dinner with me again a couple times next week, too. And I'm pretty excited about that. So, this is pretty weird. So, I'm going to have Nick on at some point, who hopefully will explain this to me and somehow make it make sense. Please please make it make sense. Please make this make sense. So, yeah, this is something that I was not prepared for, and if you had told me this, I would have called you a liar. I was like, there's no possible way that's the rule. You must be reading it wrong. There's no way that can be true. So it appears to be true. So it's a thing. So yeah. So anyways, I guess I'll sign off for now while I try to make my brain somehow recover. If you've enjoyed this stream of watching my mind try to comprehend something that my mind was not prepared for, please remember to give it a like. If you're not subscribed already, please remember to subscribe. And you know, for a mere 99 cents, you too can become an uncivilian. It's true. You can help pay for the channel, and when my mind breaks. For those of you who weren't here on Sunday, we're trying a modified recording format. It's going to require more heavy editing. I still think I have one of the old style to well, that's not true because Matt still has some stuff to relieve. So I have one that's ready to upload, and then I have like 5 or 6 or 7 more of the old style whenever Matt gets done with that editing. But some point in the relatively near future, we're going to try a different thing, and this should be fun. So you guys want to know a little bit about this thing that we're going to do? Okay. So here's what I came up with in the chat's collective brilliance. So if you watch like Attorney Tom, or you watch, a lot of people, you watch Legal, you watch a lot of these guys, like they'll try to give you something like for a hook, right? To stay at the end, and like, for example, Legal do, and I'll give you my grade for legal reason. Or Attorney Tom says, stay at the end and I'll give you my score for fault or something, my percentage score fault, right? So you give this little thing at the beginning. And the idea is, at least, is that it will entice people to stay at the end. So first of all, we're going to edit the content shorter. So we did our first recording, and we're going to have to edit it and see how it works. But our objective is to land in between 8 and 12 minutes, and maybe 15 at the outer edge, which probably won't happen, but that's our working goal. All right. So then, here's another thing too. So first I do a very short cold open where I say something like, the question in today's legal case is, say the question, right, in some sort of humorous, entertaining way. So the question in today's legal case is blah, 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 blah. And then I say, stay tuned, and I'll give you my color of law. Insert Uncivil Law logo cut here. And I'm thinking about putting the logo on screen with the words Uncivil Law and having it like radiate colors in the Capcom logo style. So any of you guys who know what Capcom looks like, have it kind of do that. I'm thinking about that for an idea, right? Okay. And so then when we get to the very end of the thing, now we say, and now I'll give you my grade of legal reasons. So we came up with a whole color scale. From red to purple, red being what? W-U-T, what? And purple being black letter. So we'll give you my color of law, which we collectively decided in the chat was a funny pun. So that's what we're working with. And if that idea sucks, we'll try something else. But we're gonna give this also means I need to have graphics made. Oh man. Okay. So yeah, we'll and we might. I don't know what we're gonna do in terms of. I might put the full. Maybe what I'll do is I'll put the full thing up on locals. Yeah, that would make sense. So I'll take the full thing in its unedited form and put it on locals. That would be good. That gives someone the incentives for locals so they can see the full thing. And then I will put the other thing. And yeah, so that will drive some traffic to locals. So that makes locals now useful. Hooray. So we tried that, and we're going to see how that all goes. Anyways, I'm going to sign up for now. Till later, my friends. I hope all is well. Cheers. And goodbye.